Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. During the recent presidential campaign, there was much discussion about immigration and temporary guest worker programs, where U.S.-based businesses hire foreign workers to come into the U.S. and provide their labor or services here. So I thought I would address today's talk from the perspective of the U.S.-based employer who believes he is in need of a foreign worker. If you own a U.S.-based business and have an interest in hiring a skilled foreign national to work for you, you'll need to consider the H-1B Visa program. This is a temporary non-immigrant guest worker program for special workers who work in occupations that require highly specialized knowledge and have a bachelor's degree or higher in the specific specialty. H-1B specialty occupations may include fields such as science, engineering, and information technology. The visa permits the worker to stay and work in the U.S. for 3 years, although it may be extended, but generally may not be extended for more than 6 years. Let's say you employ in your U.S.-based business a summer intern. She's a foreign national who attends one of Pennsylvania's premier colleges and universities. You wish to employ this foreign national upon her graduation because she possesses a highly specialized skill that you need in your business. The foreign national is legally in the U.S. on an F1 student visa, but her student visa expires soon after she completes her undergraduate or graduate degree program in the United States. Now, without obtaining another visa status, she'll have to leave the U.S. and you'll miss out on this valuable worker. So what do? You as the employer, you'd like to offer her employment in your company, and you would like her employment to begin soon after she graduates. So first, you must make sure the position you're offering fits the definition of the specialty occupation in the law, and that your potential hire has the required qualifications. If so, you can assist your potential new employee in applying for the optional practical training status. A graduating student may apply for what's called an F1 OPT status in the interim between graduation and between her H-1B approval. The OPT status is valid for up to 12 months post-graduation. And that time, you need to get her approved under the H-1B visa program, or again, she'll have to leave the U.S. and you lose out on that valuable employee. So you need to get moving on your H-1B application. You start by completing and submitting a labor condition application to the Department of Labor. In this condition application, you must agree to pay her a wage which is no less than the wage paid to similarly qualified workers, or if greater, the prevailing wage for this position in the geographic area in which she'll be working. So if you think you can employ a foreign worker for substantially less than you would otherwise have to pay a U.S. citizen, think again. The regs are designed to prevent that. You then work on your petition for a non-immigrant worker. If you're actually, and in this case, you're actually petitioning the United States government, and you're asking the government to allow you to bring this foreign worker into the United States to work for you. Now, the petition itself is a little bit complicated and a bit beyond today's discussion. But one thing you need to know is you're not guaranteed to have your petition granted. In addition to having to meet the legal criteria, there are also numerical caps, limits on the number of H-1B workers admitted to the U.S. each year. For example, the caps for fiscal year 2019, which starts October 1st of 2018, have already been met. So you're too late this year. You need to time the filing of your petition so that it will be considered and hopefully approved before the cap is met and no additional petitions are considered. So it's somewhat like a race to get your petition filed before the hundreds of other thousands of petitions are filed. So the timing is critical. The best time to file is April 1st of the upcoming fiscal year. That's why April is known as H-1B season in addition to tax season. Well, there's much more involved in successfully bringing a foreign national to work for you in your U.S.-based company. If you'd like to know more about this topic, immigration, or any other legal topic, give us a call at 717-657-7770. That's all the time we have today for the Scaringi Law Lunch Break. Enjoy your lunch.